Hi, and welcome to the Property Planet podcast. I'm Amanda Perrotten, and as always, I'm joined by my partner, Simon Howley. We're here to discuss issues of the day and bring you heavyweight experts to provide updates in law and tax. And today, as always, is no exception. So I'm delighted to welcome back Richard Gray, Ruby Keeler-Williams, and also David Brigelli from Elysium Law, who will give us an update in relation to how litigation is going in the world of Spotlight 63. So welcome to you all, and good morning.
Good morning. Thank you.
Good morning, Amanda.
Yeah, thank you.
So if I could start firstly with you, Richard. Obviously, Elysium Law, just for those that perhaps haven't listened to the first episode we did with you, is quite a niche practice in terms of you're a barrister, Richard, which is unusual almost in a private practice situation. So how do clients go about getting in touch with you, and why is it exceptional for them to be able to ring up a barrister?
Right. Well, Elysium Law basically was formed as a BSB entity. We are a firm rather than a sole trader barrister, which is the norm. We have litigation privileges, so we are able to do everything a solicitor can. For example, we can issue claims, we can defend claims, we can go on the court record, we can draft witness statements. So we can do everything a solicitor can. So our direct access is actually extended in that respect. So to all extents and purposes, we are very similar to a solicitor practice, but we are barrister led. We are small, and we specialize in various areas of work. So we think we're pretty client centric in that respect, really.
Yeah, I think it's very positive for effectively for a client to be able to email you, perhaps get you on the phone, and to just get in touch with somebody that is an expert, and particularly obviously in litigation, which is highly important in this area, given that Spotlight 63 was issued in October. Just looking, you produced a very helpful set of FAQs that I'll put in the show notes that are on your website. And I think that talking about Spotlight 63, as we did previously, which fundamentally sets out HMRC's position that they don't think that the less tax for landlords scheme is working. They've started to issue nudge letters, and they're encouraging taxpayers to get in touch with them by the deadline of the 31st of January 2024. So we've found over the last couple of months that clients are splitting into distinct categories. So there's those that think they have to do something, and there's those that think really that they can do nothing. And with 16 days to go to the deadline now, we're trying to encourage people that to do nothing is not really the route to go. But of course, initially, people will always think, but it's going to cost me more money. So how do we allay their fears in relation to that?
Well, I think basically, I think the situation is to do nothing is not an option. One of the big we've had a very large number of inquiries through the website, and we held 2 conferences last week whereby we provided information. We stressed that doing nothing was simply not an option, because we believe that there are issues of professional negligence and breach of contract in the planning provided by less tax for landlords. And as we stressed, I think on the last podcast, and I think in the FAQs, the limitation period for bringing a claim is running. If people do nothing and subsequently HMRC pick it up some considerable time in the future, and there is a problem with the tax, and we think there's no doubt about it, there will be a problem with the tax returns and the planning if it's been implemented. They will potentially lose the right to litigate because they literally will have run out of time, especially in the contract, which is 6 years from the date the contract was entered into. And once that happens, the claim is what we call statute barred. It simply cannot be brought in court, no matter how meritorious it is.
So just to clarify that point, so if somebody went into the planning, so just when the time limit starts to run, so somebody set the planning up, let's say in 2016.
Yes.
But they weren't obviously Spotlight 63 wasn't issued until October. So is the 6 years running from the date they entered into the contracts in 2016, or is the time frame running from last October when HMRC issued Spotlight 63?
In contract, we believe the time runs from the date the contract was entered into. A contract has it the express terms, which would be the payments and the work set out, and the implied term of providing proper tax advice. We believe that has not been the case, and therefore there is a breach of the implied term written into a contract. But the contract is 6 years in law, and it will be 6 years, we believe, from the date the contract was entered into. So from 2016 to 6 years, you're statute barred at 2022. We've had people who've entered, let's say, 2020, 2021. Obviously, they are still in time to bring negligence and contract. So I have to stress, the negligence claim is different from the contract. The contract is 6 years, full stop.
Okay, so could the person that entered into the contract in 2016, are they still able, so they're statute barred under contract, but are they able to still bring a negligence action?
Yes, they are.
Okay.
Because that is 6 years from the date of loss. And we believe the date of loss is when HMRC start to call in the various tax charges, the interest, the penalties, that sort of area. We believe the date of loss runs from then, or it runs now from the date that they should have taken legal advice about the position with regards to Spotlight 63.
Okay, so just to clarify for people listening that are now trying to do a quick sort of mental maths in their minds. So as far as the contract is concerned, so when you entered into the contract, that less tax for landlords put in front of you that moved the properties around, that is 6 years from the date of that contract.
Yes.
And if you want to bring a negligence action, it's 6 years from the date of your loss. So your loss
Yes.
will start effectively now, when the nudge letters, when HMRC have made it very clear that they don't think it's working.
We think so. Yep. The alternative is the loss runs from the date that the tax returns were submitted. But we think that the loss crystallizes when HMRC have viewed the tax and sorted out the tax issues, the back tax. We think the loss will start from then. But it's really important, and we have to stress this, not for our sake, but for the client's sake, that they engage with authorized tax advisors, and they engage with us initially for some primary advice on those particular points.
Yeah.
What if there is no contract though? Because there seems to be a lot of paperwork missing from all the planning. So I think that they're probably quite consistent, and therefore I can't see any kind of letter of engagement being put in place for the planning.
Well, the vague information we have is that what Less Tax for Landlords did was what most clients have called the hard sell. And one client contacted me yesterday. We spoke yesterday morning. It was a £3,000 simply for the quote the team meeting, and then there was a letter put out saying we can help you. Thereafter, there was an engagement letter, which I have to tell you wasn't very thorough, and we were certainly happy to publish a redacted version with the client's permission, and we do have the client's permission. The contract itself is very vague. It certainly doesn't set out in detail what it sets out what they're going to do by way of forming companies and LLPs and the mixed partnerships, but in no way, shape or form does it set out any sort of tax advice as to how this system works. Yeah, but I still think they would say, given the hard sell, given the you've signed a contract, I think arguably they would say, well, the contractual claim runs from the date they entered into that contract. That with respect is really of not much concern to us, because negligence is still very much alive presently to the clients. If you are within the contract period, this is very complicated, then in any claim we would plead breach of contract and/or negligence. So we'll pursue two limbs of the same. The same action.
I think just go back to your point, Simon, even in cases where there isn't a written engagement letter, there's still not a bar to a breach of contract action, because contracts, you know, of course, you'd prefer that you would have a written engagement letter from a professional advisor, but you can have oral contracts, and that's not a bar to potentially a breach of contract action.
Okay.
So just as another point, just to clarify for obviously people that are listening, is that I think some clients have been concerned that HMRC would know that they'd perhaps initially got in contact with either you, Ruby, or Richard, if HMRC are going to find that out. So we've got two camps of people, that some that have got nudge letters, some that haven't got anything. And perhaps the ones that haven't got anything are thinking, oh, well, I'll sit tight. And perhaps to actually do something, to get in touch with a firm such as yourselves or with us, will actually put them on the radar for HMRC. But that's obviously not the case.
Do you want me to answer that?
Yeah.
The situation is, I think we discussed this, and thank you for bringing it up, because again, it was brought up last week. We are not here to give client details to HMRC, the details of those who entered into less tax for landlords, SKS, or the Baily Group, or which is a similar type of planning. We're simply here to gather names and see, in fact, whether they want to take the litigation forward. Any information we have is confidential. We can't divulge it without the express consent of the client, because it's subject to privilege. And I think I raised on the last occasion, in fairness, HMRC contacted us over a client once, wanted to know where the client lived. Say again, very honestly, we didn't know. He was a foreign national. But I did say to the chap, in any event, it's legal professional privilege. We couldn't tell you. And good enough, he said, I'm sorry, I hadn't thought of that. So we would not, it's, with respect, it's none of our business with regards to the HMRC angle. We wouldn't tell that. We assume that, obviously working with you, that if you take up the client's retainer with the client, then you necessarily will be contacting HMRC, as it's in the client's interest to do so. But it's a preliminary call to us. No, we just take the name, give them some preliminary advice as to what the best next steps are.
Yeah. So we had a podcast that we did last week, actually, with Adam Craggs of RPC and Patrick Way, KC, and we were briefly talking about penalties and the starting point. So just being mindful of the time that's seriously ticking down now. So with 16 days to go at the time that we're recording this, if you haven't got in touch with HMRC, bearing in mind they issued the spotlight in October, we were discussing initial penalties are likely to start at around 30%. So that's 30% of the tax that HMRC assess you otherwise should have paid. So just in terms of how this will start to mount up for the clients, what is your advice in terms of mitigating and or how they form part of any claim?
You must mitigate your loss in any litigation, and we've stressed that completely. So early engagement with HMRC and the reduction of penalties or interest, quite obviously, don't quite know how that's going to work, but any reduction in, if you like, the overall tax liabilities has to be encouraged. If you engage in litigation, looking at the specifics of less tax for landlords, for example, the first thing the other side will want to know is, have you mitigated your loss? How have you mitigated, lessened the loss that you're asking us to pay for? I think one of the issues on that actually is that people think that if we bring an action against less tax for landlords, it will be less tax for landlords who will be defending the action. That is not the case. Less tax for landlords have professional indemnity insurance, as far as we are aware, and professional indemnity insurances insurers will instruct very experienced insurance company solicitors to defend these claims. So less tax for landlords, to a large extent, will drop out the picture. And these solicitors are very experienced, they're very able people in our experience. And the first thing they will want to know is, how, if at all, have you mitigated your loss? If you don't go to HMRC now and you don't engage through someone, for example, yourselves, and mitigate those losses, we will have a serious amount of difficulty later on in trying to actually formulate a claim.
So do you think that it will failure to mitigate your loss could actually stop you being able to claim, or would it be able to, or would it reduce the amount that you're able to claim?
I don't think it would stop it per se. I don't think it would stop it if, for example, you had a tax bill twice as much as, I mean, this is hypothetical, twice as much as you would otherwise had you mitigated your loss. But then, of course, we're then in a scenario, aren't we, as lawyers, of trying to negotiate or agree as to what the likelihood of loss was. And in the schedule of damages, you see, in a professional negligence or breach of contract claim, that we'd run both. They would want to know what the initial tax liability was, what the liability is after HMRC have been engaged, what the loss is therefore, what the interest is, what the penalties are, etc. It would be very difficult, if not impossible, to try and formulate a claim where somebody is literally sat back and allowed HMRC to rack up the penalties and interest to a considerable extent. And I think at that stage, we would take this on a risk basis. We may well say it's far too risky to run your claim because the damages that you've incurred are far, far more than you otherwise would have. And it's now not possible or very difficult to actually determine what would have been the position had you engaged. So it may well be that would ruin any possibility of the litigation going forward for various reasons.
Okay.
Exactly.
Sorry.
I have two concerns, really. One is if clients don't really get involved with HMRC or by the deadline date, because then you're giving HMRC the argument that you're trying to conceal something. You're not going to volunteer information, therefore you're racking your penalties up to 50, 60% maybe. Not saying you're going to go toward the criminal side, but other concern really is the planning seems to be pretty templated. So it's pretty much they're just changing names, dates, addresses, and that's really it. So I mean, would a PI insurer kind of think, okay, well, this really, all these, say, 100 clients, it's all the same, really. Would they block it all together as one claim? Or would they pay out at per claim as is the norm for insurance?
Well, that would depend upon the existence of an aggregation clause. Generally, it has to be said, the aggregation clause bites, and therefore, if you've got 20 or 100 claims, they would be classed as all one claim, if you like. But what we're looking at, and we had this a lot off the clients, what we're looking at, I mean, I think just pausing there, it's very important that if there is an aggregation clause, that you mitigate your loss as far as you can to maximize what you're going to get from the aggregation.
Yeah. So it's even more important.
Very much so.
Yeah.
And we've stressed this to the clients in the two conferences last week, and we're going to stress it again. As I say, we're going to put out a series of posts. But I think, other than that, I think we are looking at, insofar as we're looking at the less tax for landlords, certainly, and we're looking at the insurance for OCG accountants, because we understand that's a separate policy of insurance. Whether they are negligent in submitting the tax returns that they have done, knowing the background to less tax for landlords with whom they are connected, and frankly, we say potentially, and it's only a potential, we're investigating whether they knew as competent accountants, professional advisors, that the structure put forward by less tax for landlords, on respect of which they submit the returns rather long-windedly, was negligence on their part as well. We also understand that, and again, we don't know and we make no aspersions here, we don't know what part OCG Legal pays. They're an SRA regulated firm, so they'll have professional indemnity insurance. And overall, between the three, we believe that there's about 7 million's worth of insurance, even with the aggregation claims. So that's get your mitigation in, get your claim in,
Yeah.
and get within those particular parameters of payments.
Yeah.
Because I have one case, as I can't, I'm going to call a client about an hour's time. His planning was put in place by, I think it's Chris Baily, separately outside of the less tax for landlords kind of umbrella. I assume that's going to be brought into the same umbrella kind of.
Absolutely, we have one client we spoke to the Christmas period, the week between. He went with Chris Baily, and then there was some sort of amalgamation or transfer to the Baily Group. We're not quite sure yet, but he's going to send us the material. He's a very helpful client, and he tells us that Mr. Baily has tried to exclude liability, and SKS have tried to exclude liability. Well, we'll be looking at those exclusion clauses. We don't know whether that's the case, to be honest about it. But it seems to us that potentially at least SKS will actually take on the liability of Chris Baily. It doesn't seem to us that they could take on all the assets and get rid of all the liabilities in an amalgamation. We don't know when. Someone might be able to assist me. I don't know when that happened, but Mr. Baily himself should have runoff insurance as well.
Yeah, true.
Yeah.
So all of these things,
yeah.
sorry, all of these things have to be investigated, and that's why there's a lot of work behind the scenes between you and HMRC and us with regards to the clients who want to engage with us.
Mm-hmm. So
I think as well. Sorry, Amanda. I think as well, on your point about why clients should come forward, really limitations as well a relevant factor, and it keep going back to something that you said yourself on your website, that HMRC's internal deadline for investigating these claims aren't necessarily going to align with the civil claims. And in the event that HMRC come back in 10, 20 years time and there are interests and penalties, at that point limitation has run out and there is no recourse for the client against the advisors who advise them. So really there is actually, at some point these liabilities are going to be incurred, and it's better to come with open hands and to reach a tax compliant position and then have that limitation period open for you to take to obtain some kind of recourse against those advisors.
Yeah, I mean, we have noticed with the sort of the SDLT schemes from the early 2000s, some of those are still coming through now, sort of 15 plus years on, and you're absolutely right. They do take a considerable amount of time to filter through, by which time, of course, as you say, limitation periods have become irrelevant, consider a long time ago. So just in terms of your conferences last week, were there recurring themes from clients? What were clients' anxieties and comments that you noticed last week?
Mostly the aggregation clauses was one, and we think we've satisfied our clients as to that. Secondly, I think engaging with HMRC, one of the we understand from Dan Needle's post that Less Tax for Landlords wrote and said they'd engage leading counsel. We don't know much about that at this stage, but they've engaged leading counsel to advise Less Tax for Landlords to write to HMRC about something or other income, we think. I mean, as I say, we don't know much about it. I think it's really important. And the clients brought this up, saying Less Tax for Landlords are going to represent us at HMRC. When counsel, I think it's really important that when counsel is engaged to advise, counsel is engaged to advise Less Tax for Landlords. Counsel is not engaged to advise all of the lay clients or all of the clients of Less Tax. So if HMRC reject the position, there will be potentially litigation. If HMRC reject the position, counsel is always under a duty to revise his or her advice and say, well, that's a very strong position and I don't advise litigation. Now, I can't see how Less Tax for Landlords, in engaging counsel and not advising these people to engage with HMRC directly, is good advice. Because what I don't want is for the client to think that leading counsel is there to advise them, because leading counsel isn't. That's the retainer, and we've seen that with leading counsel Mr. Thornhill in the McLean case, I think last year, where they tried to sue Andrew Thornhill QC, or KC as he is now, and the court just rejected it and said there's just no retainer between counsel. So you know, you can get a silk who's absolutely, you know, HMRC are going to reject it. You know more about this. How long are they going to take to reject it? If they do reject it, does the silk then get involved and say, well, I think it's worth litigation? If the answer is yes, who's going to pay for the litigation? If the answer is yes, how long is the litigation going to take? And then, so the clients thought last week we're well protected here. And I said, no, you're not. And as Ruby's just said, all the time that limitation period is running. And I think one of the things about the SDLT position that you mentioned, if in some time in the future, less tax for landlords go into liquidation, their runoff insurance will be 6 years. If we don't go back within 7, there's no insurance. We need to strike now. We need to, if necessary, get standstill agreements in place to stop the limitation period running. And once that happens, we can all not so much relax, but at least we can take stock of the position through experts like yourselves as to say, well, how long is this really going to take to shake down? I think one of the issues that somebody said to me the other week, just in passing, was, and it's, you'll know better than I do, how long has it taken for the contractor loan planning to settle? Years and years. They're still going on. People still having settled. We don't do that work. But we, you know, people still having settled. The SDLT we're aware of, because we got advised to on insofar as directors' disqualification proceedings are concerned with one firm. So yeah, it's a mixed bag. There's only one way forward in this: instruct the expert, properly engage with HMRC. If you want to come to us, we will then liaise with the chosen expert, and we will advise the clients as far as the potential causes of action, the funding, the best next steps, and once engaged, we'll seek standstill agreements.
I think as well, the thing is that surely there must be a conflict of interest, because it's obviously in less tax for landlords' best interest, or whoever is engaging the KC, to demonstrate what they want it to demonstrate, which is not necessarily in the client's best interest or the layperson's best interest. And so with an obvious conflict of interest, sitting and waiting for advice for somebody that's actually not advising you seems the worst possible position to be in.
Well, I think
also, it's also important to understand, or the clients to understand, that counsel will only answer the questions you ask them. You can phrase the questions in a certain way to get an opinion that is more favourable. They're not going to go out on a limb and volunteer information without being prompted to do that.
Well, there's definitely a conflict of.
Can't hear you.
I think we've lost Richard there, but I think from our perspective as a firm, that we've got 4 factors we're considering. We would consider the conflict of interest point, as you said, consider whether the client can rely on the advice, we'd consider the scope of the advice, and we'd also consider, again, any limitation and how long, you know, that advice would take to implement. Richard, I don't know if you're back.
Yeah.
Oh, yeah, we can hear you now, Richard. Yeah,
you can. Thank you. Yeah, I mean, the conflict of interest, I did raise, I mean, Dan Needle has raised that, as you know. Yeah. And I did raise that with the clients and say to them rhetorically, how is it on the basis that everybody except less tax for landlords thinks that the planning does not work? Have less tax for landlords giving you any technical information as to why they believe the planning does work? I don't think they have from the feedback, and I'd invite them to do so now. If they're acting in the interest of their clients and they say that every tax advisor who says they're wrong is incorrect, well, I'd like them to say why. But I did say to the clients, how do you think it works when, for example, we are threatening to sue everybody, every tax advisor says it doesn't work? How is it in their interests to represent you? And I did explain that if you are challenged with a real sort of a challenge that you are negligent, you're under a professional duty to advise the clients to seek independent advice. Not in some way, shape, or form trying to emasculate it and kick the can down the road, which I have to say, from the information I have from the clients, I think that is, if that's not the intent, it's the effect. Let me be as charitable as that. Really, it's not in the interest of these people to rely on less taxable landlords to represent their interest. But again, I'm not as skilled in tax, for example, as Simon, but I have to tell you, I've not seen any pushback from less taxable landlords to say this is why it all works and everybody else is wrong.
There's nothing. I mean, it's, and even from the early days, watching some of the videos of them at various shows, it's just utter nonsense.
Well, sorry,
crazy.
Simon. I think I said to you, a very esteemed colleague of mine who's chartered tax advisor, etc., engage with them, and with his client's permission, he was redacted, and I was shown the discourses between him and less tax, and when you actually filtered it all down, it was basically, this works because we say it does.
Yeah.
And I'm seeking actively the permission of my colleague to actually publish this as an example of how the hard sell worked. And then people can take up the cudgels and say these answers are really meritorious on behalf of Mr. Baily or less tax, or they are complete nonsense. And I would invite, when I publish it, and invite comments. But I said to the clients, write to less tax or contact less tax and say, well, what are your answers to the challenges of the spotlight? Because it's important to recognize it's not only income. This business about lifting a base cost uplift on the LLP, it's just rubbish. It's rubbish. And can I tell you, the week before, we were approached, and the chap's coming back to us, and he tells us that he sold his properties, submitted his tax return on the basis there was a base cost uplift. HMRC queried it, came back to him and said, actually, the initial tax is incorrect. You now owe us over 800,000 in capital gains tax. That's one person.
That's
the other problem I tried to explain to Mandy with the clients last week was this business about business property relief on death.
Yes.
It's just rubbish. Yeah. And as far as I can see, I'm happy to be corrected. The problem is, I said, if you've got two partners and one claims BPR and it's disallowed, and it will be, there'll be an IHT liability. Fine. How are you going to pay the IHT liability? Well, probably you're going to have to sell the properties.
Yeah.
Where does that leave the partner who's still alive? Because I'm happy to be corrected now, but that will give them a CGT charge, won't it?
If they sell, yeah.
Yeah. So I said, so you've got two partners and they're selling all the properties to pay your IHT, but actually as they're selling the properties, they're racking up their own CGT bill.
Yeah.
And if this happens in 15 years' time, where's less tax for landlords then? And they're not going to be. It's the old sort of isn't it? The tax avoidance scheme planning, isn't it, from the noughties?
No, the BPR point is just utter nonsense. It always has been.
Yeah.
And the tax-free uplift in the LLP again, because it's transparent.
Exactly.
Again, it's just nonsense. But it's anyway.
So they were the sort
repeating myself.
They were the sort of questions, and I think people listening to this podcast, and we're going to do a series of missives on this. We're going to get this out there and say you need to consider this, that, and the other, because the initial response from less tax does not deal with the capital gains. It doesn't deal with BPR. It seems only, as far as I know, to deal with the income distribution. Yeah.
Well, very, very useful as always. And I'm sure, still reiterating the point, doing nothing is not really an option. So we're really grateful for you all joining us again.
Thank you.
Today. Thank you
the
very
invite.
much. And we, as I say, we'll include your FAQs in the show notes, and share extensively anything else that you issue that's useful for clients. So thank you all very much, and we look forward to maybe an update in a few months' time.
Absolutely. Thank you both.
Certainly.
Thanks, Amanda.
Thank you
Thanks,
so much.
Simon.
Thank you.
Bye.
Bye.
Bye.